In this video, I will explain how wealthy families lose everything in probate and how to avoid it. By the end of this video, you will learn the 3 critical mistakes that destroy family wealth and the exact strategies wealthy families use to protect their assets from probate court. I'm Santiago Cueto, board certified international business law expert and best-selling author based right here in Miami, Florida. I've watched too many families lose their inheritance in probate court when simple planning could have saved them millions of dollars. A successful Miami businessman spent 40 years building a $15 million real estate empire. He died suddenly last year. His family just discovered that they'll lose nearly half of everything to legal fees and taxes. And this nightmare happens every single day across America. And let me tell you what really happens in probate. Your family discovers your death, they're grieving, they're emotional. Then the legal nightmare begins. First, someone has to hire an attorney. That attorney files paperwork with the court. The court appoints a personal representative. This process alone takes weeks, and sometimes even months. Your bank accounts get frozen during this time. Your family can't access any money. They can't pay bills. They can't even pay for the funeral without the court permission. But the bills keep coming in. The mortgage payment is due. Property taxes are due. But the court hasn't given anyone permission to touch the accounts yet. Your family has to use their own money just to keep everything afloat. Now the real costs begin. The attorney charges by the hour. In Florida, probate attorneys typically charge between $300 and $500 an hour. A simple estate takes at least 40 hours of legal work. That's $12,000 to $20,000 minimum. Complex estates with business interest or real estate can take hundreds of hours. Then there are court costs, filing fees, publication fees, appraiser fees, accountant fees. These add up quickly. But here's where wealthy families lose the most money. It's not the legal fees, it's the timing. Your real estate portfolio needs to be sold, but probate takes 6 months minimum. Often it takes over a year, sometimes 2 years or more. The market doesn't wait for probate to finish. Properties sit vacant, they deteriorate, they lose value. Your business interests become frozen assets, and business partners can't make major decisions without court approval. And opportunities pass right by, and competitors take your market share. The business value plummets while everyone waits for the court. Your investment accounts can't be managed actively. The market drops. Your stocks lose value. The personal representative can't reallocate without court permission. And your family watches the portfolio shrink while waiting for legal approval. This is how a $15 million estate becomes $8 million by the time probate closes. The attorneys didn't steal it. The court didn't take it. Time destroyed it. Let me share a real story. I represented a family whose father owned commercial properties in Coral Gables. Beautiful buildings, prime locations worth millions. He died without proper planning. The properties went into probate, and the probate process took 18 months. During that time, 3 major tenants moved out. The personal representative couldn't quickly lease the spaces without court hearings. The building sat partially empty, income dropped. The family had to sell at a discount just to pay the estate taxes and legal fees. That family lost over $2 million, not because of bad investments, not because of market crashes, but because of probate delays. Everything becomes public record. Your assets, your debts, your family disputes. Anyone can walk into the courthouse and read your entire file. Predators watch the probate filings. They target vulnerable families. Scammers call your widow claiming you owed them money. Distant relatives come out of nowhere demanding their share, and business competitors discover your weaknesses. Privacy disappears entirely, and family relationships often get destroyed in the process. Brothers stop talking to sisters. Everyone thinks they deserve more. The stress of probate brings out the worst in people, and I've seen it 100 times. Now, if you're finding this information valuable, do me a favor and hit that like button right now. It helps more families discover this critical information, and subscribe to my channel because I share strategies like this every single week. All right, so how do families avoid this disaster? They use 3 key strategies. Strategy number 1 is a revocable living trust. This is the foundation of every good estate plan. You transfer your assets into the trust while you're alive. You maintain complete control. You can change anything. You can revoke the entire trust if you want. But here's the magic. When you die, the assets in the trust don't go through probate. Your successor trustee takes over immediately. No court involvement, no delays, no public records. Your family accesses the money right away. And the trust continues working exactly how you designed it. Real estate gets managed, businesses keep operating, and investments stay active. Nothing freezes, nothing stops. I had a client who owned a chain of restaurants. We put everything in a trust. He died last year. His daughter became the successor trustee. She walked into the bank the next day with the trust documents and the death certificate. The bank gave her full access immediately. The restaurants never missed a single day of operation. Compare that to probate. Another restaurant owner I knew died without a trust. His restaurant went into probate. The court process took 14 months. During that time, 3 of his 5 locations failed, and the remaining 2 lost so much value he barely had anything to pass on. All right, strategy number 2 is beneficiary designations. Your retirement accounts, your life insurance, your bank accounts. These can all have beneficiary designations. When you die, these assets transfer directly to your named beneficiaries. No probate, no delays. But here's the critical mistake I see constantly. People set up beneficiary designations and forget all about them. They get divorced and forget to change the beneficiary. Their ex-spouse gets everything, or they name one child as a beneficiary 20 years ago. Now they have 3 children, but only one is listed. That creates a legal nightmare. So review your beneficiary designations every single year. Make sure they align with your current wishes, and make sure they coordinate with your trust. And strategy number 3 is proper business succession planning. If you own a business, your operating agreement needs succession provisions. Your partnership agreement needs buy-sell provisions, and your corporate documents need transfer restrictions. These documents control what happens to your business interests when you die. Without them, your business goes through probate. Your business partner might end up in business with your spouse. Your spouse might know nothing about running the business, and the whole company could collapse. I structure business agreements so ownership transfers smoothly outside of probate, and the surviving owners or your chosen successors take control immediately. The business continues without interruption. Now let me address the biggest objection I hear. People say that setting up a trust costs too much. They don't want to spend the money on estate planning. But here's the reality. A proper estate plan costs between $3,000 and $10,000 depending on the complexity. That's a one-time investment. Probate costs typically run between 3% and 7% of your total estate value, plus the hidden cost of delays and lost opportunities. On a $2 million estate, probate could cost $140,000 or more. That trust suddenly looks like an incredible bargain. The second objection I hear is that people think they're not wealthy enough to need planning. They think trusts are only for rich people, but that's completely wrong. If you own a home in Miami, you probably have significant equity. If you have retirement accounts, life insurance, and some investments, you likely have over $1 million in assets. That's enough to make probate expensive and painful for your family. Everyone needs estate planning. The question is whether you want to plan now or force your family to deal with probate later. Now here's my challenge to you. Sit down this week and list all your assets, your home, your cars, your bank accounts, your retirement accounts, your business interests. Add up the total value. Then ask yourself this question. Do you want your family to lose a chunk of that to probate, or do you want to protect it? The choice is yours, but you have to make it while you're still here. Your family can't create a trust after you're gone. They can't avoid probate after you die. This is your responsibility. Handle it now. Now, if you found this video helpful, make sure you like it and subscribe to my channel. I create content like this every single week to help you protect your wealth and your family. Your support means everything. I'm Santiago Cueto, your Florida business attorney. Be sure to watch more of my videos right here.